Hello, everyone. Good afternoon. Welcome to my November edition of my construction webinar series. For those of you joining me for the very first time, my name is Tashia Rasul. I am a partner here at LOIS Law Firm where I practice the defense of workers' compensation claims, but also I specialize in construction claims. I oversee a team who handles construction claims exclusively, the attorneys and the paralegals. They're very versed with how the construction sites work and all of the terminologies and most importantly, all of the issues that are faced in litigating these claims and trying to reach global settlement with the goal of reducing exposure for our clients. We consider ourselves the experts in this area, and one of the reasons I bring this webinar series once every month is to just do bare bones construction defense 101. I touch a little on the general liability side to the extent that I know what's happening on that side. For those of you who have joined me in the past, welcome again. Thank you for continuing to follow me. All right, so happy November. I hope you all had a great Halloween. I did with my kids, took them out trick-or-treating. I now have a lot of candy to eat, so I am happy. All right, so what are we going to discuss today? This month, we're talking about calculating exposure in multi-jurisdictional cases. And what I mean by that is the workers' comp and the general liability or the civil or the third-party component. So I'll talk about the factors to be taken into consideration when calculating exposure. We'll talk about our friends Kelly and Burns and why they drive us crazy ever so often. And I'll do some crunching of numbers and show you exactly how I calculate exposure and present it to my clients. And just a reminder, this is a live webinar. So in the end, you'll have the opportunity to send me some questions. Hopefully I know the answers to your questions. But if I don't have enough time, you can also email me your questions. And this is what the box is going to look like. So type your questions in there and it'll pop up in my end. All right, so let's get into it. I hope you have a pen or a pencil, some paper, and maybe some coffee or tea because I may bore you when it comes to the Kelly and Burns stuff. All right, so factors to be considered in the workers' compensation claim. Now, claimant's demographics. Why do we need to take this into consideration? We're looking at the age, prior injuries. This gives us a really good idea if this claimant is going to go back to work, if he's planning going back to work. Usually, if it's a younger claimant, no prior injuries, they're a little more motivated sometimes to go back to work. If it's an older individual, they're just looking at retirement and then will be on the hook for many, many years of potential benefits for them. We're also looking at whether an MSA is needed. This is very important because the medicals do make up a very big component of any settlement, especially if the claimant's had multiple surgeries and also especially if the claimant is older and has more pre-existing degenerative conditions that are contributing to a failure to heal properly and so forth. They try to like convolute all of the treatment and then the MSA just is driven up. We should also take into consideration any apportionment opportunities. This is golden. It's our opportunity to reduce our exposure by pointing our fingers to prior employers and insurance carriers. And if successful, it could help to reduce exposure significantly, especially in those occupational disease repetitive injury claims where, for example, the claimant is a plumber or an electrician or an iron worker for 25, 30 years, and he's now on our job site for 1 month and is claiming that he has finally, decided that he finally has injuries that results of his 25 years of work, and now we're trying to tack the liability back on the prior carrier. So this is very important, and we should always be looking at our files for apportionment opportunities. Additional factors, medical status. This is very important. For those of you who handle the workers' comp claims, you know we have e-case. The claimant and his doctors and his attorneys are responsible for uploading the medicals. This is how we check it every week. We're in there looking at what the updated medicals are, what they're saying about degree of disability. Oh, wait, he's being referred to Dr. Marola. He's going to be chopped up in a couple months. We know, we kind of know where the medicals are going to go based on who the claimant's attorneys are and who their doctors are. So it's good to know the medical status, and based on this experience of knowing who's who and where it's going next, we're kind of able to predict the medical future of any particular claim. We look at things also like, is he actively treating or not really treating? Because if he's not, then we know it's kind of winding down, his injuries weren't serious, and we're gonna wrap this up sooner rather than later. We look at the surgeries that the claimant underwent. I mean, we all know surgeries never make a claimant better, right? They always make them worse. Why? I don't know. Let's hear what the doctors say, deposition after deposition, right? They always come up with a reason. But we should always be fighting this and keeping in mind the surgeries that the claimant underwent when we are getting an IME. So hopefully the IME is going to say, well, the surgery actually helped the claimant to improve, or you know, the claimant is expected to improve within the next 6 months as a result of the surgery. We should also be looking at medications. So medications is really a driving factor of the medical component. I've seen MSA after MSA that allocated tens of thousands of dollars, sometimes hundreds of thousands of dollars only to long-term medication use, which I personally think is unnecessary because it's in the doctor's report saying that the claimant needs it. The vendors and CMS, you know, they want to be overprotective and include this, but ultimately, whenever we are bound to the MSA, it drives up the exposure. So that's something we want to take into consideration also. Overall status of the claim, looking at the claim holistically, the claimant's return to work status. For the very few cases, especially the construction cases where the claimant actually returns to work, we like those because you know, indemnity benefits are practically zero going forward, provided he stays out of work. And usually when they return to work, medical treatment dwindles also, right? Because they're fine, they're not seeking medical treatment to support their claim for indemnity benefits. So something we should always take into consideration. Legally, any fraud findings, one of the things that we always try to do is keep an eye out for fraud findings. We communicate that with our GL counterpart, and they use it in any number of ways to leverage their claim, to negotiate settlement, and so forth. Fraud findings, for the most part, we would have a suspension of benefits, so that also cuts off indemnity payments, and that gives us a good idea of where the potential exposure is going to be on the claim. And of course, any permanency findings or potential permanency findings. This is the bow and the gift to the claimant, right? His permanency findings is going to determine what he's ultimately going to get in the claim. So if there's any SLU or LWIC findings in place, we pretty much have to go by that. We'll talk a little more about that in this presentation. Or potential permanency findings. We can calculate it based on the impairment guidelines, the IME, doctor reports, and the claimant's medical reports. Definitely take that into consideration. All right, so I'll talk a little bit about the general liability claim, some of the things that I've seen that I think we need to take into consideration in evaluating exposure from the comp side. The strength of the liability and damages claim. How do we get this information? We get it from our GL counterpart, right? Whether it's the GL claims adjuster or the GL defense attorney. I personally stay in touch with the GL defense attorney, try to talk to them ever so often to see what's going on in their claim, what they need from us, and most importantly, how they're feeling about their defenses on that end, right? Because that helps us to make a recommendation on our end, whether we should do a standalone or global settlement the globals are usually preferred, just so you know. Jurisdiction, a lot of times I'm talking to my GL defense counterpart, and they talk about, well, in Queens this is going to happen, and in Bronx we expect this to happen, and in Richmond County we expect this to happen. They also give us good insight about what the jury's going to think in any of these jurisdictions, right? So that helps us to get an idea of where they think the GL claim is going to go. And of course, potential exposure. I know this changes. A lot of time this information is not available in the very beginning of the GL claim because they have all sorts of experts that they're relying on to help them calculate potential exposure. But as soon as they have any information, we start inquiring about it. And that also gives us an idea of where we are or where we're headed on the workers' comp claim and settlement. And so I know I'm just saying in general terms, it gives us an idea. It's hard for me to explain for these factors that I just went through. There's no putting a number on it or putting like a percentage on any of the factors. It's just based on our experience and how we see the cases go after doing them. I've been doing this for more than a decade now. I just kind of know how some cases are going to resolve. And I gotta say, I'm usually pretty on point. All right, how to calculate exposure. So here we go. I apologize for any headache in advance. Now, there are two lines of exposure, the indemnity and the medical. In the grand majority of cases, we're closing out both of these at the same time. In some cases, we're closing out the indemnity, leaving the medical open, because the claimant just wants to make sure he has enough coverage for future treatment. With the global settlements that I've talked about in previous webinars and that I'm a big proponent of, we usually close at both the indemnity and the medical portion also. We just want the claims to go away, right? We don't want any additional exposure. So in addition to thinking about the indemnity and the medicals and where we want to go, we have to look back. We have to look back at the prior payments paid to date. There are some cases where we've paid out $10,000 total for indemnity and medicals. Those are the better cases. Other cases I've had, we've paid out hundreds of thousands in both the indemnity and the medicals, and that creates a little more complications with the crunching the numbers and determining how to settle and when to settle the claims. So for indemnity, we're talking about two main things here. We're talking about SLU findings and LWIC findings. Now, keep in mind, a lot of times we're settling cases even before we get to the permanency phase, right? So if there's no current finding, we try to use the IME report as a guidance. If we don't have an IME report, I'd recommend getting it because it's our own medical evidence. And, we're not solely relying on the claimant's doctor's treatment plan in trying to predict a potential permanent impairment. In the meantime, I usually use the claimant's doctor's findings as my worst case scenario, right? I never trust them for my best case, although I know I'm going to attack them on deposition and the claimant on cross-examination because I'm going to have a great IME. I use it for a worst case, just in case my client wants to know, hey, do you think we're going to end up with a 75 or a permanent total disability? Or let me take a look at what his doctor is saying. But keep in mind, we're going to have our own IME. Be sure to reference the impairment guidelines. I've seen a lot of times where we're talking about potential exposure, like, all right, we'll end up with a 50% LWIC or a 35% SLU, and I'm looking at the analysis that I get from maybe the claims adjuster or whoever is crunching the numbers. It's very, very important to reference the impairment guidelines. They are clear, they're concise, they tell us what to do, they tell us what percentage is allocated to a particular injury, all of the criteria that needs to be met. This is how we're able to predict the 60% LWIC, the 75% LWIC, or the 25% LWIC. We should be incorporating them into our analyses. For SLUs, if there's been a finding, then we know there's no additional money moving for indemnity, except in rare cases where they would file for a reopener to reopen the indemnity portion because there's a change in condition. That something is usually litigated, but it happens only maybe like 1% of cases. Generally with the SLU, they take their payments and they go away, right? And they stop trading. So there's no more indemnity exposure for the SLU when there's been an SLU finding. For the LWEC cases, and so just to clarify, I'm sure you all know the SLU cases are generally the limbs, the shoulder, the elbows, the wrist, the fingers, the knees, the feet, and the toes. The LWEC cases, which is what we see in the construction cases because of the nature of the accident, someone's always fallen from a scaffold or a bucket or a step stool. It's almost always a fall, right? So the neck's injured, the back's injured, supposedly, and those drive up the cost of the claim. Or traumatic brain injury, which is like the new back fusion. That's something they're pursuing now. Anyway, so for those kinds of cases, we're looking at LWEC, loss of wage earning capacity. That's how permanent impairment is calculated in those cases. If there's been a finding, take into consideration the amount of LWEC paid out already. What I mean by this is for LWEC, there would be a cap, 300 weeks, 400 weeks. If you've already paid out 100 weeks, then you should be getting credit for that when you're calculating or negotiating settlements. We should also be taking into consideration the present day value of the outstanding LWEC awards, right? We're not giving away extra money here, no extra dollars for the claimants. If we were to give you the lump sum money today, we're doing it at the present day value, not what it would be at the end of 400 weeks. Okay, medical exposure, I just talked about it a little bit. We should be looking at the recommended or the planned treatment. What is the anticipated cost? The claims handlers, the adjusters are very good with putting this together because of their expertise, looking at the medical fee schedule, the actual cost that they would have to pay for a particular treatment. And with our experience seeing certain doctors or a certain group of doctors and certain attorneys, we know where the medical is going to go. So in collaboration with the claims handlers, we're able to say, all right, well, we think this guy's really going to undergo this additional surgery. He's going to try to do an additional year of cognitive treatment, even though it hasn't been working or even though he hasn't needed it. But we do have to, for the most part, take into consideration that future treatment. Again, the medications. Will this claimant need medications forever? Oh yes, we've seen them. They need it forever, supposedly, right? And again, if the MSA is needed, the liability will be based on the MSA, especially if we have to get CMS approval. We have to disclose the MSA and we'll be stuck with it. So if the MSA is coming back at $300,000 and the claimant's on Medicare, and we have to get CMS approval, then we're going to have to pay out the $300,000 for that. All right, so Section 29. Section 29. This is something we do all the time in these construction claims when we're talking about global settlements or when there's a third-party claim. So I refer to the third-party claims as the general liability claims. I don't know, it's more sophisticated, I think, but it's the same thing I'm talking about, right? Section 29, workers' comp law, Section 29 provides that a workers' compensation carrier that has paid out indemnity and medical benefits has a lien on the proceeds of any third-party settlements. Now, clients often ask, well, they're really suing me on the GL side or the third-party side. Do I still have any Section 29 rights here? Because it's really the same pot of money. And I'm talking about like the OSIPs and the CSIPs, the wrap-up clients, right? And my answer is, of course, yes. I mean, it can be done two ways. It can be done in negotiation of settlement, will waiver a lien, a full waiver or a partial waiver, in exchange for a $0.32 and a certain amount on the GL side. That's usually the easier way. A little more complicated way with some back and forth would be, all right, so we recover a lien and then we take that money and we pay it out on the Section 32 and then we close the general liability claim and the workers' comp claim at the same time. That's a lot of like back and forth, and I think we lose a lot of negotiation leverage when we do it that way. So the answer is Section 29 applies, and use it in negotiating settlement. Okay, how does the reimbursement work? So here's where we talk about our friends, Kelly, Burns, and Bissell, right? They're the ones that really laid out how the Section 29 lien reimbursement works. So I'm going to try to make this as simple as possible. But as a reminder, this webinar is being recorded, so you can go back and watch it. And if you have any questions, reach out to me directly. I'll try to send you maybe like some of the slides, the info, and the examples that I'm going to put up, because I don't know, it took me a while to learn. You know, no denying it. It took me a while to wrap my head around this, and it's not the easiest, but we'll get through it. Okay, so Kelly, our friend Kelly addresses indemnity benefits, right? Burns also addresses indemnity benefits, and I'll go through the difference in a second. And Bissell addresses medical benefits. So we've got it all covered. These are the seminal case law. These are the ones that we follow in calculating how much we're really entitled to under reimbursement. Let's start with Kelly. So under Kelly, well, so to start with, workers' comp carriers receive two potential benefits from settlement of third-party action. The first is reimbursement of its current lien, the indemnity and medical paid to date. So if you've paid out $100,000 as of today, you're entitled to recover your share of that $100,000, all right? And the other situation is where the workers' comp carrier would be responsible for ongoing benefits. You can take a credit against the payment of these ongoing benefits until the third-party settlement proceed is exhausted. And this is what is commonly referred to as the holiday. Kind of like taking a holiday from payments. Then when you've recouped your money, then you start making payments at the regular rates again. Okay. So Kelly outlines how reimbursement calculations are to be made. And it applies in situations where the claimant's future workers' comp benefits are non-speculative. Sorry, I don't really know how to pronounce that word, but you know what I mean. Or in cases where the claimant is no longer receiving workers' comp benefits at all. Okay, so non-speculative means cases where there are death benefits, we know what's going to be paid out. Scheduled loss of use, we know 35%, that's going to be paid out. And permanent total disability, we know that that's not going to change. It's going to continue until the claimant dies, right? The rate is not going to change because we don't have a claimant to return to work. Okay, so next, to do a Kelly calculation, we need to know the gross workers' comp lien, that is the indemnity and medical paid to date. We also need to know the present value of the future benefits. So those death benefits, the SLU, the permanent total disability, we have to crunch the present day value. We need to know the litigation costs expended in the general liability claim. We get this at the time of settlement, the closing statement. Sometimes we just get the information verbally or through an email. You know, the attorney's fees are X amount and we paid $5,000 in costs. And then we need to calculate the percentage of the third-party claim, the reimbursement that was, the proceeds that was spent on the litigation, right? So once we know what the attorney's fees are and the costs, we have to calculate what percent. And what I'm talking about is the common 1/3, 33%, right? That's the standard, but sometimes we do get specific and it's like a 34.9%. And that's how we use to calculate our reimbursement. All right. How to calculate the actual reimbursement. So under Kelly, the gross workers' comp lien or the gross workers' comp lien plus the present day value of the future benefits minus the litigation percentage, which is generally, like I mentioned, the 33.33%. It can go as high as 36. I've never really seen anything higher than that, If you have, let me know. I just think it's within that range. Here's an example and a break from my face. You get to watch this screen now. Okay, so we have settlement amount here of $400,000. Your litigation costs, your fees and disbursements, $140,000. Litigation cost percentage would be the 140,000 divided by the 400,000. We have 35%. Your lien to date, the total amount is $90,000. 35% of your gross lien would be $31,500, which would be your the amount that we work with, right? Because we have to reduce it by the litigation cost percentage. So your actual workers' comp recoverable lien would be that grand $90,000 less the $31,500 equals $58,500. So of that $90,000 you've spent to date, you are legally entitled to recover $58,500. And then just to show you what's going to go into the claimant's pocket here, because I know that's important when we want to do the settlement, we want to see how much this guy's really getting. If his net settlement proceeds are $400,000, he spent $140,000 on litigation costs minus the lien that we're going to recover, he's going to get $201,500. All right, I'll leave this here for a second. And let's move on to the next example. Oh, I should have been clear. So this is an example where there's no future benefits. So we're doing like a section 32 at this point. The next example that I have here is where the claimant's benefits are continuing, right? So we talked about the death benefits, the SLU, or the PTDs. The settlement amount here is $400,000. The litigation cost still $140,000. The percentage is still 35%. The lien is still 90%. Now we have to calculate the future benefits. So $300 a week permanent total disability benefits. That's my example here. The claimant's expected to live an additional 40 years. The total he'll get is $624,000. And we're just going to assume for clean numbers that the present day value of $624,000 is $100K. So the lien plus the future benefits is equal to $190,000. And then we have to reduce that by the 35%. So now we're wondering, wait, why are we not reducing only the prior, right? Only the prior paid indemnity and medical. This is because the distinction here is because there's ongoing benefits that he's actually entitled to. So the $90,000 lien is then reduced by the future benefits, so less $66,500, and we get $23,500, and this would be the recoverable lien amount, and then the workers' comp carrier get to take a holiday on the balance of it. All right, so the net settlement amount that's going to the claimant, it would be $236,500. And just so you see the math here, it would take the workers' comp carrier about 788 weeks, 15 years to pay out the net amount of the settlement if we were doing $300 a week. And then the carrier would get to take a holiday for 15 years and resume the payments at $300 per week until the claimant dies. All right, I hope I didn't confuse you there. Let's move on to the final Kelly example. So this is an example where the claimant's benefits are continuing and the workers' comp carrier may need to pay fresh money. What fresh money? I know there are some situations where we have to, and it really depends on the prior amount that has been paid. So I think it's very important for us to consider this also, because we don't want a claimant's attorney saying, hey, the reason why we have a higher settlement demand and we're not budging is because my guy would be entitled to additional money going forward. So in this situation, the settlement amount is $400,000 again, litigation costs $140,000. The 35% remains. The lien is only $20,000 here. And the future benefits, we're using the permanent total disability benefits here again of $300 a week and the same present value of $100,000. what we have to do is add our current lien paid to date to the future, the present day value of the future benefits that we're going to be liable for. And if you see the math here, 35% of 120,000, we get 40,000. And the 20,000 lien is then reduced by the future benefit. So we're subtracting the 40,000 from the 20,000. Now we got a negative 20,000. So what do we do here? That doesn't seem right, right? Here's where the carrier then has to pay the $20,000 in fresh money. The claimant settlement proceeds in this situation, after crunching the numbers, would be about $280,000. And the carrier would then get to take a holiday for approximately 18 years to recoup that money. All right, these are the three classic Kelly situations. And so Kelly is usually the less popular one that we talk about when we're doing the construction claims. The focus is usually on Burns, but there are a couple things I have to point out about Burns and what exactly it stands for. So as I mentioned earlier, Burns also discusses the indemnity portion of the claim and how to get the money back, how to calculate the money, right? So it outlines how calculations are made when the future benefits are speculative, where we don't know exactly what's going to be paid out, like an SLU or a permanent total disability. All right, it's going to be like our general LWEC case where we have a permanent partial disability situation. Also, something to note, I have it here up on the slide with regards to like a permanent partial disability. If you're wondering why that is considered speculative, it's because the claimant can return to work and the benefits would cut off, or there would be a reduced earnings claim and award made where you're actually paying less, so it could potentially change. So there's still some speculation as to what you're really going to pay out. Okay, bear with me, we're getting through this. So unlike Kelly, where the benefits are calculated at the time of settlement, benefits are calculated on an ongoing basis. So we've all heard it. We're going to be doing it at the Burns rate, right? We're going to be paying indemnity and medicals at the Burns rate because it's ongoing. The claimant will continue to receive payment at a reduced rate, and the rate is being calculated using the Kelly formula. So see the connection, Kelly and Burns. The formula, the Kelly formula is actually used to calculate the Burns rate. There's a little bit of a distinction between the cases there. All right, so the payments will continue until the claimant's net settlement amount is exhausted, until you've recouped all that you're supposed to have recouped on the workers' comp side. And after the Burns payments are exhausted, full payments are going to resume in the workers' comp claims. After, let's just say you've gotten your $400,000 back, then you start to make the usual amount of the workers' comp payments. Here's the classic Burns example with your settlement amount of $400,000, litigation cost of $140,000, the cost percentage of 35%. Here your lien is $90,000. 35% of $90,000 is $31,500. Your workers' comp recoverable lien is $58,500. The net settlement to claimant is going to be $201,500. And here's where we talk about the Burns rate. Your weekly benefit payment amount that you're going to continue paying, because payments are required under the workers' comp claim, the claimant's still out of work, would be the Burns rate, and it would be 35% of the weekly benefit. So if your weekly benefit's $300, your Burns rate would be $105. This is very clear cut. I think the complications are more with the Kelly calculations, but I think it's important to understand how the different Kelly calculations work, because at the end of the day, your settlement evaluation, they're all in the numbers that we're going to crunch, right? The decision to settle or not settle, or to do a standalone versus a global, that decision is really in the numbers that we're crunching. Finally, BISL. Let's not forget about our friend BISL. Medicals are very, very important. It's very straightforward. This case actually talked about how medical benefits are reimbursed, and the carrier's right to take their burns credit also. So if the medicals remain open, the workers' comp carrier is liable for its equitable share of litigation costs and future medical benefits. So it's usually at the burns rate, and it's usually as the treatment occurs. So we never pay a lump sum, and courts can direct how the payments are made. But I don't think I've ever seen a case where the board says something other than the claimant's going to undergo the treatment, he's going to pay for the treatment, and then submit the bill to the insurance carrier for reimbursement at the burns rate. That's really how it's done. We have a handful of cases that we weren't able to settle that are still open, and we're paying the burns rate. And that's generally how it's done, and that's how we keep track of what the potential medical exposure is going to be. All right, so I just went over this. The claimant's responsible, and then the court can say how it's going to be done. All right, so that's it. That's it for calculating exposure in multi-jurisdictional claims. Those are all the factors that I look at when I'm telling my client what I think the claim is worth. Like I said, I'm usually on point with the exposures. It's just because of my years of experience doing this. So, you know, if you want to get an idea of what the real value of your claim is, ask your attorney. If they're experienced and they know what they're doing, they should be able to pinpoint all of the factors that are taken into consideration, all of the treatment issues, and giving you a very close estimate. I think it's very key also to talk to your general liability counterpart to see what they're thinking. And this also helps us to come up with a decision with regards to whether to do a full lien waiver or partial lien waiver. Those are all the things I talked about in last month's webinar. So if you missed that, you can take a look at that one. The links are on our website. But overall, one of the things I've been preaching all year long and for the past 2 years when I've been doing these webinars is communicate. Communicate with your attorney, with your adjuster, and with your GL counterpart. I've seen demands for millions of dollars being reduced to like $1 million, under $2 million, and it's really because everyone's on the same page, everyone's sharing their knowledge, and they're crunching the numbers the right way. Let's not give the claimants extra money. Let's not give the claimants' attorneys extra money. Let's do it right and do the calculations properly. So this is going to be recorded. It's going to be placed in our website by the end of the week. You can go back and watch it. If you want me to send you the slides with the examples so you can go over them more clearly, or you'd like me to go over them, give me a call and I can walk you through it. All right, so that's it for today's webinar. I will see you here again next month. December 6th is our final one for the year. I'm going to do a little bit of a wrap-up and wrap-ups. See what I did there? And I'm going to talk about some notable case law in the construction area this year, workers' comp, and there's a couple of GL ones that I'd like to talk to you about. So we'll talk about those. And as always, if there's anything you want me to address, like, let me know ahead of time and I'll try to incorporate it into the webinar. All right, thanks everyone. Have a great November. Happy Thanksgiving. Enjoy the rest of your fall. I'll see you here in December. See ya.